Hey guys, and welcome to the Working Money Channel. So yesterday, did we ever see a red day in the crypto space? Bitcoin did actually go below $40,000, a psychological level that so many people were talking about. That's represented here by that red candlestick. We have rebounded up right now. Bitcoin's trading at about 40,200, so back up above that $39,000 mark. So the market cap right now at about 1.85 trillion. But Bitcoin dominance, guys, this is what we should be looking at. This is what is really important. And I personally don't think these moves mean too much until we've actually seen, well, a couple of things here. A, until we see Bitcoin retrace significantly, and B, until we see altcoins rally. So I'm not suggesting that we are in a bear market quite yet. As a matter of fact, I still think Bitcoin will make new all-time highs. And, you can even get a sense of this just based on looking at the entire market. Altcoins are all moving in tandem with Bitcoin right now, and that is, again, represented by Bitcoin dominance. We aren't really seeing that number move. So Bitcoin here under $39,000 or under $40,000, does this mean much? I don't know. I'm going to venture to say no, not too much. We're still trading on low volume too, right? So the XRP price had slipped as well. Right now it's trading at about 70.5 cents, but it is also rebounding today. You can see that green candlestick slowly forming here on the daily chart. And here's the total crypto market. I have this trend line here from a video I did previously. You can see, even just with regard to the trend, again, this is the total crypto market, including Bitcoin. You can see we are still above that trend line in and around here. And if I bring up total too, so all cryptocurrencies excluding Bitcoin, you can see altcoins are still up above that trend line as well. So I'm not getting too worried quite yet. Frankly, the $40,000 threshold, that psychological mark, doesn't really mean too much, considering it is just a psychological level and does not really represent anything significant other than psychology of traders. If I throw up this Fibonacci here on the latest trend, you can see, so now we are below the 0.236. And again, guys, we are going to have to see a grind to the upside. We still haven't seen this. Right? The 702, this is what's going to get altcoins to rally. So if you think that Bitcoin is bearish and it is going to make lower lows, well then by default, you should also automatically assume that altcoins will not rally, right? Because Bitcoin still does need to retrace. Money needs to come out of Bitcoin and into altcoins, and that's when we see, boom, the final move down, making lower lows, signifying truly a bear market for the crypto space. And we just have not seen that yet. So I'm still quite optimistic. Again, this could be a grueling move to the upside too over the next several months. It could take months before we see that move. And then at this point here at the 0.702, that will be the deciding factor of what we will see for altcoins and Bitcoin at that point in time. Now remember, bull markets tend to take longer over the course of time, as we have witnessed in the past. 2013, that bull run didn't last that long compared to the next bull run, which was 2017. And so if we were to just take a look at the bull runs and how long they take to play out, we can see that extension, the stretching out of the bull runs. And if I were to compare the 2017 bull run to if we were to assume Bitcoin's top was $69,000, well, those bull runs have taken the exact same amount of time, which then negates that theory. So, we're going to keep an eye on it. There is some big news coming down from the Ripple SEC lawsuit. XRP Darren here posting this. How does it feel? Conclusion, the SEC's motion for reconsideration is denied, and its motion for clarification is granted. The clerk of court is respectfully directed to terminate the motion at ECF number 429. And so that was ordered by Judge Sarah Netburn just yesterday, guys. So in my opinion, a huge win for Ripple yesterday. This means that Ripple will get to see the Hinman emails, however many it is, whether it's 68, 63, I've heard 58. And this will happen unless the SEC is able to successfully appeal to the judge. So in a lot of ways, this is signifying the beginning of the end of the lawsuit and perhaps a nice unexpected bullish pump for XRP once we get some more concrete evidence that Ripple is closer to winning the case. So James K. Filan here posting this yesterday afternoon, yesterday evening, XRP community, the court has granted the SEC's motion and approved the SEC's proposed redactions of the notes of the meetings between SEC employees and third party. And so here is the document. It is linked in this tweet. And of course, as always, I link all the tweet threads in the description of the video. So Judge Sarah Netburn did sign that. The court allowing the SEC to hide proposed redactions of the meetings between SEC and third parties is no surprise, considering they don't want to make the government look bad. A bunch of clowns, says XRP Crypto Wolf. So what does this mean? Let's get into it, guys. James K. Filan always bringing us the latest updates with regards to the Ripple SEC case. So here is what was breaking yesterday evening. The court has denied the SEC's motion for reconsideration of the DPP ruling and granted the SEC's request for clarification of that ruling. And so here's a quote. The SEC has identified no intervening change of controlling law or any other controlling decisions unaddressed by the court's January 13th, 2022 order. The SEC's assertion that the speech was intended to communicate corporate finance's approach to regulating digital asset offerings is inconsistent with the SEC's and Hinman's previous position that the speech was intended to and did reflect his personal view. So we're going to get back to that in a second. The SEC seeks to have it both ways, but the speech was either intended to reflect agency policy or it was not. Having insisted that it reflected Hinman's personal views, the SEC cannot now reject its own position. And so James K. Filan here reiterating, and I'm going to punch in on this slide. This is a very big win for Ripple. The XRP community can see it. You know, if you've been following this since the beginning, you have likely seen the progress of events. And, you know, there have been ups and downs. It's been like a roller coaster ride for all XRP hodlers. And so, you know, we're just keeping glued to the updates here. And, you know, we wouldn't be able to do that without XRP community members like James K. Filan. And, of course, you know, the lawyers involved dissecting this case that are also part of the XRP community. So before we go into that, I want to bring you guys some extra information here with regards to what occurred before Ripple got sued. So Wilbur54-XRP posted this: the Clayton calendars. Jay Clayton did not make the decision to sue Ripple on his own, and Gary Gensler was the main influencer in his decision. So note this: Gary Gensler could have actually been a bigger influence even before he entered the SEC than we have perhaps originally thought. They met 4 times as early as March 2018, and Clayton met with Ripple in between. So isn't that interesting, noting that he did have meetings with Gary Gensler from back in March of 2018. And then if we keep going here, we keep scrolling, we can see August 20th, 2018, Jay Clayton did have a meeting with Ripple, including Brad Garlinghouse, David Schwartz, and John Roscoe, special assistant to the President, White House office, and presidential personnel. And then let's keep going here. This would be from November of 2020, phone call with Gary Gensler, President-elect Joe Biden's transition team. Also in November of 2020, November 30th to be exact, another meeting here, a phone meeting with Gary Gensler. And then finally here, December 14th. So again, guys, this was all before the lawsuit was announced. Meeting with Gary Gensler at 1:30 p.m. on December the 14th, Monday, December 14th, 2020. So all these meetings were taking place before the Ripple lawsuit was officially announced. And if you guys don't remember, Gary Gensler was actually officially sworn in, I believe it was March of 2021. So there were all these meetings, even ones as early as March 2018, with Gary Gensler, at that time senior lecturer of MIT Sloan School of Management. So, you know, this to me seems to be one of the more interesting meetings so far before Gary Gensler was sworn in to be the new SEC commissioner back in 2018. At that time, we know he was lecturing about blockchain and cryptocurrencies, so it was likely that this meeting had something to do with that. The calendars for April, May, and June of 2018 are inaccessible. Isn't that interesting? Strange that. Who did he meet before the Hinman speech in June of 2018? The final meeting they had before Clayton walked out the door was December 21st. Again, another meeting with Gary Gensler, President-elect Joe Biden's transition team, as Gary Gensler would have been sworn in a few months after that. So interesting posts here from Wilbur54. I also wanted to just mention this XRPJJ here on Twitter. It looks like the Blockchain Association made this chart in January of 2019. They tried to get the SEC to adopt the Hinman token standard test. So is this more evidence suggesting that Hinman's speech was indeed supposed to be, at least originally supposed to be, the official guidance? The table below shows our best understanding of the factors Director Hinman laid out and the factual record for Bitcoin and Ether on June 14th, 2018. And so this is just a chart. I'm not going to go over this entire thing, but I will link it in the description of the video. But just gives you guys some information here. Decentralization feature mentioned in the Hinman speech, and then it gives some examples. Ether token and or Ethereum network on June 14th, 2018, and it gives a description of that. Bitcoin tokens and or the Bitcoin network on June 14th. And all these things coincide with the topics along the chart. Threshold for sufficient decentralization. And so you can see examples of that. So for example, do persons or entities other than the promoter exercise governance rights over meaningful influence? Well, defining governance is more complex for a token network than for a company. This is with regards to the Ethereum token. The Ethereum Foundation and its creators of Ethereum are heavily involved in developing the rules of the network, though others have influence. With regards to Bitcoin, yes, again, even if there is a promoter of Bitcoin, governance and influence are highly dispersed and not tied to any initial group. And then with regards to the threshold for sufficient decentralization, promoters may continue to be prominent in governance so long as they are not in exclusive control of the direction of the project. So there are different examples here from the Hinman speech specifically. So if you guys want to go over some of those, it will be also linked in the description of the video. Wanted to thank XRP JJ here and Wilbur54 for posting some more information with regards to uncovering more clues, all having to do with the Ripple versus SEC lawsuit. But here we go, guys, present day. And here's where we stand with regards to the lawsuit. John Deaton chiming in on yesterday's ruling. I was wrong before when I said there were 52 drafts of the Hinman speech. The judge writes, as evidenced by the 68 drafts and associated commentary in the SEC's privilege logs, 68 drafts with lots of commentary. There's a strong chance XRP is mentioned. He goes on to say, Judge Netburn added a bulletproof section for any appeal to the Second Circuit. She could have flat out denied the motion for reconsideration pursuant to Rule 6.3. Can't raise new arguments you didn't the first time. Instead, she recognized how important the DPP doctrine is. She didn't just summarily deny the motion, but analyzed the SEC's substantive DPP argument and then rejected it. I love it. What she did was take away any argument on appeal based on how important DPP is and that this judge didn't consider it like she should. Can you say brilliant? She called out the SEC for its inconsistent positions related to the speech. She said you don't get to change your position just because you didn't like the court's conclusion. She highlighted the inconsistency by drawing specific attention to Hinman's under oath testimony. She threw a bone to the SEC by clarifying the SEC could seek leave to redact those communications from its production. That implicates other separate agency deliberations, not deliberations about the content of the speech. So you guys can see here, John Deaton has underlined all those sections for you guys to peruse at your leisure. On one hand, this is good because it also makes this order bulletproof. Any appellate court will see that the judge is honoring all privileges under the law. There is no way, in my opinion, Judge Torres on the Second Circuit disturbs Judge Netburn's ruling. On the other hand, what exactly does separate agency deliberations mean? We would know what she means if we had access to comment 12 on page 6 of the speech draft in document J. In other words, she gave a specific example of what can be redacted by the SEC. The SEC is not allowed to redact agency staff communications about edits to the speech, and the edits themselves can't be redacted. The judge will review the proposed redactions. If XRP is referenced in the 68 drafts, which John Deaton thinks there's a very good likelihood that XRP was mentioned, and or in the commentary, Ripple gets it, and XRP wins. Booyah! Coming from John Deaton here, a great analysis of those 68 drafts and possible redactions. The fact that XRP is likely, there's a strong chance XRP is likely going to be mentioned in and amongst that. Let's keep going. Jeremy Hogan also chiming in. Judge Netburn sticks to her guns on the DPP issue and reorders the production of the emails related to the Hinman speech. The order includes some uncharacteristic SEC chastising from our judge. I'm mirroring her in stating that as politely as possible. He continues on down here by saying the order is a little concerning, however, because she allows redaction of parts which discuss separate agency deliberations. So Jeremy Hogan a little concerned about that. My concern, he says, it's those parts of the emails that are most damaging to the SEC. How will we know? If the SEC appeals up to Judge Torres, they are in trouble. Down here, XRP Crypto Wolf, Judge Netburn is getting sick of the SEC going back and forth trying to hide Ethereum and XRP documents. 8-bit Slong down here saying, you think that's why the SEC released that batch of emails to empower? Ripple Effect, I don't know who slapped harder, Will Smith or Judge Netburn. Jeremy Hogan, I wish I had thought of that one. So a little bit of banter down here in the comments section. We're getting a lot more information, a lot more input from some of the XRP community lawyers, including Bill at Balsarius 2020. I was concerned about that too, Jeremy. So talking about Jeremy Hogan's point about being a little concerned, because although the judge seeks to confine what the redactions should cover and even give an example, the past behavior of the SEC and its lawyers suggest that the SEC will seek to redact much more than the judge contemplates should be redacted. So could it be that the SEC will redact even more than should be allowed, I guess, in these subjective terms? The judge already allowed the redaction of document J, which was one of the 10 the SEC submitted to her. This is a redaction to a comment, to a comment 12 on page 6 of a draft of the speech. Even the description of the document dated February 17, 2022 was heavily redacted, and so he gives just a screenshot of that, just showing us how much of this document was redacted. And this document J, this is the same document John Deaton was talking about. I believe it was down here somewhere in the thread. Or was it? Document J over here, comment 12 on page 6 of the speech draft in document J. So he's also a little concerned about that. The specific material for redaction identified by the judge concerning this document has been allowed. For any other redactions, the SEC must seek leave. The right of the SEC to claim privilege on other grounds is also allowed, as it was in the decision on January 13th, 2022. So doing the best I can, it seems there was an email from the Associate General Counsel, Laura Jaruslik, on June 12, 2018, that contained 12 or more comments on the June 11th draft of the speech. The judge is allowing comment 12 on page 6 of the draft to be redacted. From this, I assume 11 or more comments on the June 11th draft are not covered by DPP. Comment 12 must fall under what the judge describes as being in the context of how it implicates other separate agency deliberations, so it shows that the scope of redactions is narrowly confined. So his concern is that the SEC will seek to go beyond this as much as possible to seek to cover up what Jeremy Hogan described as a possible smoking gun. Who does he think will be in trouble, SEC or Ripple, asks Kellen Harris. And so he says he means the SEC. The decision of Judge Netburn is very fair and well written and will be difficult to set aside. Allowing limited redactions makes it harder to argue the release of the document with limited redactions will have any chilling impact on real SEC deliberations. Also, just to make it clear, Nicholas Bond asks the question, I was under the impression that the judge would have seen the unredacted copies, and Bill responds, she has only seen the 10 documents out of 63 that the SEC provided to her. So a little concerned about the amount of redactions that could take place, and if this could affect the case. Could they be covering up a smoking gun? And if so, how will this impact the final verdict? Wrath of Kahneman also putting in his 2 cents here. Now he's saying, I'm not a lawyer, but the Wrath of Kahneman, as we know, a critical thinker coming up with some interesting and compelling arguments and thoughts. What does this latest ruling mean? The court ruled the Hinman speech was not official deliberation, and therefore the communications surrounding the speech can be viewed, save one comment, because they weren't part of any policy deliberation. For now, there are 2 implications. 1, Hinman can't be claimed as guidance by the SEC, so what can? Does this strengthen the fair notice defense? 2, what is in the communication surrounding the Hinman speech? What would be damning here? An admission of no clarity, perhaps? It's interesting that Garlinghouse and Larson asked for the communications around the speech for the fair notice defense, as the judge makes it clear. And the court notes after searching them, the SEC raised objections. And I think this is pretty important too. The definition of what is fair notice is getting tightened. Okay, so it was a broader term before. Wrath of Kahneman noticing that we are kind of zeroing in, we're kind of laser targeting the true definition of fair notice. It's getting tightened up for further arguments. It seems like a shot across the bow for the judge to say telling companies to come in or we'll work with you is not guidance. So really kind of differentiating between what is, or rather what should be guidance and what isn't guidance. Come in, we'll work for you. That is not guidance whatsoever. That is almost like baiting a company in to understand their workings. And then if they are not adhering to the guidelines you see fit, take him to court, which is exactly what happened to Ripple, saying that SEC staff are happy to help promoters and their counsel work through these issues, or that staff stand prepared to provide more formal or no action guidance, does not render the speech itself agency guidance. So the court is coming out and stating that. I believe that one comment was just an example of what NetBurn meant, this coming from Cameron here on Twitter. Since the SEC needs to be perfectly clear on what they can provide, it seems that they can and will likely redact more. I mean, if I were the SEC, it would be in my best interest to redact as much as possible, to have no leaky points in the case. However, I think it's a little late for that. So some interesting insight there from the Wrath of Kahneman. Stefan Hubert also mentioning this: the SEC cannot reject its own position. Judge, you will see you had no idea. Also just retweeting out this tweet that I mentioned earlier from the James K. Filan thread. The SEC seeks to have it both ways, but the speech was either intended to reflect agency policy or it was not. Having insisted that it reflected Hinman's personal views, the SEC cannot now reject its own position. The Wrath of Kahneman also bringing this point up. This is heartening to see in the court's decision. They can see what the SEC is doing, and it could have some real reverberations. So again, from the court's ruling with regards to the Hinman speech, and they've highlighted this as the speech's purpose. The SEC's assertion is that the speech was intended to communicate corporation finance's approach to regulating digital asset offerings is inconsistent with the SEC's and Hinman's previous position that the speech was intended to and did reflect his personal views. So we are seeing a lot of discrepancies here. We want to have it both ways. We want to have our cake and eat it too. And I mean, the judge, they are catching on to this. Disclaimer, by what the SEC is doing, I don't mean anything more than proffering a contradictory argument. Dingo ate my XRP wrote, I always thought of the fair notice defense as a safety net, but more and more it feels like Ripple's most potent weapon. So the fair notice defense is obviously going to play a critical role in this, likely going to be one of Ripple's most successful arguments, or if we want to use the weapon analogy, most powerful weapon against this case. Wrath of Kahneman responding, yeah, and it is interesting, if I read correctly, that the judge lands on the side of the Hinman speech cannot be formal guidance. I imagine folks hope the SEC got pinned to the opposite corner. So, there's that argument. There's the is it not? His guidance, we do know, though, it is not clear and it is inconsistent, and I think that is what's really going to sink the SEC. The fact that they do not have a clear argument, and then there's the redactions. Are we going to be able to see, is the SEC going to be able to redact enough to strengthen their case, which would in turn be negative for Ripple? Are they looking to hide the smoking gun, and will they be allowed to hide the smoking gun with the redactions? I don't know, guys, but I want to just bring it back to this James K. Filan tweet thread. I think all in all, more and more, this is the beginning of the end. James K. Filan has even said this is a very big win for Ripple. Another reason why spec price right now isn't really worrying me too much, because even if Bitcoin does fall, once we get clarity for XRP, I think, and I'm fairly confident saying this, that XRP could actually be the catalyst for an altcoin rally. And not only that, maybe the clarity will give the entire crypto market justification to rally even more, including Bitcoin. That's just my opinion, but I want to hear what you guys think. Please subscribe to the channel if you haven't already. Like the video if you like the content I'm providing. I always love hearing your comments. See you in the next one, guys.